Chairman and the ranking member, and for your all's work on this, and would concur with my colleague from Kentucky and others who have noted the rarity of the significant amount of agreement on this. But we joke about it, and we should frankly marinate in it for a minute. Yeah. And the point that the ranking member is making about what we're going to hear on the next panel, which I will take at their word will be well intended, but the extent to which it is going to diverge from what these two gentlemen are saying, and what we're saying here on a bipartisan basis to ensure that we are protecting the civil liberties of the American people, notwithstanding the concerns that are no doubt going to be laid before us by the Intel Committee, usually, I'm going to say somewhat cynically and pejoratively, cloaked in all of the mystery of intelligence, meaning it's hard to attack. It's designed with a cloak very purposely to make it difficult to attack. Because we're trying to speak in very real terms about the civil liberties of the American people, things that we are very familiar with. I, as a former federal prosecutor, for example, have had to deal with these in real time, right? And had two different cases in which I had different events occur where I was arguing to get evidence in and was successful and it was the right thing and I had to go to court, but it took a lot of work to get the evidence in, to demonstrate and prove that it was properly obtained. And I believe it was good, and we put that bad guy in jail. There was another guy, I had a phone, and the cop had taken the information off the phone. We had all these pictures, all this great evidence. I mean, extraordinary evidence of guns and drugs and gang activity. But he didn't get a warrant. The phone was just, it was incidental. They grabbed it when there'd been a stop, and we didn't have a right to look at the phone. So we couldn't use it. It was horrible for me from the standpoint of I had this great evidence. I wanted to go after this very, very bad guy, but I couldn't do it. That's important. It's really important. And it's important that we have judges that will enforce that on prosecutors. Because left to their own devices, law enforcement, lawyers who want to go get a bad guy, they're going to go do that. And 9 times out of 10, it might be well intended. Or maybe it's 8, maybe it's 7, I don't know. But the fact is, we can't give up the protections in order to seek, as our friend Mr. Armstrong said in a meeting this morning, I'm going to quote him because he's not here, I shouldn't have said that, but colleague, pointed out, notably, the extent to which it is obviously beneficial for us to have all of the information we could possibly have on everybody at any given moment in order to go pursue evil or bad actors. It'd be great, right? You can't just run around, as I think he pointed out, with dog sniffers running up to every single house to see if you can find drugs. Right? This would turn our entire system on its head. And yet, that's what our Intel community brothers and sisters want us to do. And that's wrong. And it's wrong no matter what that means, frankly. Yes, we need a balance here. All of us look at this with the seriousness and the resolve of trying to strike balance. But I would just ask now that both of the gentlemen, that there's a long laundry list of things that are included in the underlying bill. Let me back up for a minute. Do each of the two gentlemen, the chairman and the ranking member, believe that the underlying bill from Judiciary, the Committee of Jurisdiction, would be the proper bill for us to be moving forward with if you had your choice, and do you think it is a better product than either the Intel Committee product or the compromise product that is currently before us?
Yes.
Yes.
And do you think that should be the bill we start from if you had your choice?
Yes, if we had our choice, but that's not what's happening.
Okay, so the bill that we have before us is a compromise product, the product of a committee. I'm going to pause for a second. We've raised a number of issues in this committee about process over the last year. Some good, some bad. Learn some, you kind of go as you go. But the whole goal has been to try to improve the process, open things up, bring bills forward, be able to amend them, and we've hit some walls along the way. But this, I would argue, is somewhere in between, right? This is not what I would argue the best product. The best product here would be to take the Judiciary Committee product, the Committee of Jurisdiction, bring it forward, debate it, amend it. Intel guys want to bring forward amendments, make them in order, and then take it to the floor. That would be what I think is the proper process. And I raised this on the question of the rules process and what is the proper way to do these things. This is, I would consider, if I'm being gracious, a hybrid that is not just slamming something down up here as just some product that was cooked up behind closed doors by one individual, by a leader, dropping it on the floor and saying, okay, you guys vote on it. This was done with 3 people from each Intel and Judiciary in a room, sit there and find out what they can agree to, and then cook up some possible process to get certain amendments made in order. Okay, I'm just saying that for the beauty of the American people to understand what happened here. That's what happened. This is a quasi-cooked up behind closed doors bill. Now, we're going to take that bill, and then we're going to say we're allowed the base text, which we can talk about in a minute, and 3 or 4 amendments from each group, maybe 6 or 7 amendments, and that's it. We're not opening it up. We're going to say those are the amendments. And then we got to put those on the floor and then decide what that's going to mean for the future of civil liberties and security for the American people. In that context, and given that background, I want to start with how good is the underlying product? What are some of the things that you would say are actually good in the underlying product? And how is the underlying product deficient without amendment? Obviously, I know the warrant issue, but just in broad terms, like, for example, this underlying product, to the best of my knowledge, has a number of things in it, like requiring the FBI to obtain prior approval from supervisors or attorneys before making any query using a United States person query term, prohibiting political appointees from being involved in the process, requiring mandatory audits for the United States person queries conducted by the FBI. I've got a list of like 20 things.
Yeah.
And those things, I guess we would agree, do improve the current system. Would each of the gentlemen agree that those are modest improvements on the current system?
I would say yes, and
We'll get to the comma, however, but yeah.
yeah, no, but I would just say yes, and I mean, I can do this later, but I just view the whole thing as, while it's not the process that I think some of us would prefer, I still see the glass as half full.
Right.
Because we are going to, I believe that this committee makes an order, and I think this committee is going to make an order, the warrant amendment and the other 2 that we think are so critical. We're going to get a chance for the first time to vote on those on the House floor. So I see the underlying bill as the glass is half full. I see the amendments as definitely the glass is half full if those are made part of the rule, and we get to vote on those on the floor.
I think what I would say, without going through the entire list here, is what I'm trying to get at is that, the glass half full thing, which is there are a large number of things that are modest improvements that get that glass half full. Maybe it's reduction from 5,000 people having access to this stuff to several hundred, right? Maybe it's requiring FISA to produce transcripts of certain proceedings and to provide Congress with the opportunity to review those transcripts, requiring summary justifications in the case of applications to extend existing FISA orders, requiring the removal or suspension of federal officers who commit misconduct before FISC. There are things in here, right, that move the ball down the field. I say that to say, in terms of the context of what we have to decide in the Rules Committee and then on the floor, okay, that's moved down the field. Now here's the critical question that the chairman just alluded to, and I'd like to hear the views of the ranking member as well.
I think,
How short is it?
I think it moves, to use a football analogy, because
Yeah.
you were saying moving down the field, it moves it from the 0-yard line to the 5-yard line. Not much. It makes minor changes to FISA. You've mentioned some of them. It doesn't deal with any of the basic problems. It would have been better if they'd taken from a process point of view, if they'd taken our bill. They didn't. So let's deal with the situation we have. The situation we have is we have a bill that makes a very minor changes, moves the bill a little in the right direction, but is still wholly inadequate and does not protect the civil liberties of the American people. The 3 amendments that the Judiciary Committee is advancing would make this bill protect the civil liberties of the American people and provide all the necessary intelligence without compromising the intelligence. And that's why I urge the committee to make these 3 amendments in order. The 3 amendments that you're going to hear from the Intel Committee go in the wrong direction. And I would urge that they not be made in order. If they are made in order, we'll have to debate them on the floor, hopefully defeat them. If some of them pass, we may have to defeat the whole bill.
I assume the chairman concurs with what the ranking member just articulated?
Oh, yeah, we got to have the 3.
And here's something I think is critically important. We've heard arguments from some of our colleagues, presumably on both sides of the aisle, but notably from the GOP side of the aisle today, that this is somehow a second warrant requirement. As one of our colleagues articulated that this morning. That, in other words, it is already lawful, this was the framing that I was presented with, to collect this information, right? But I think that misses a really important part of this, right? And both of you alluded to it, but I want to answer it in that context here for those listening around the building. that this system under 702 lawfully collects information outwardly, right?
Exactly right.
But the key point here is then how can it be used for and toward and about American citizens?
Yep.
That's right.
Or for persons in the United States, to be more specific. And so could you both expand on that? This is the critical question, right?
It is the question. Our basic principle, and I think, who was it who said that before? I don't remember. One of the members of the Judiciary Committee, in fact, I think it was Mr.
It was Thomas, I think.
I think it was Mr. Massey, said, we can spy on non-American citizens in Moscow or in London or wherever. They have no constitutional rights. An American citizen, or for that matter, someone visiting the United States, has constitutional rights. 702 is designed to enable us to collect information about foreigners elsewhere. Inevitably, in collecting that information, you're going to get information about Americans, because Americans make phone calls overseas, whatever. You shouldn't be able to use that information without the standard way you use information for any purpose, which is to say with a warrant. So we provided the warrant requirement, which is fundamental, and we provided 3 exceptions to the warrant requirement to make it workable: the emergency, the consent, and the cybersecurity. We've put in the data broker thing just so you can't circumvent the warrant requirement. And that's what we're doing. Now, these amendments from the Intel Committee go in the wrong direction and would submit American citizens under certain circumstances to surveillance without a warrant, and that's why they should be rejected.
I would just add, I think sometimes we forget what the F in FISA stands for. It's for foreign intelligence. And so, of course, it's collected lawfully because you're collecting it on a foreigner. There's no requirement for a warrant or anything when you go get information on a foreigner. But then when you're going to use that information that brings in an American, a U.S. person, as the ranking member said, you need to get a warrant if you're going to use that.
Would anything in this underlying bill, plus the adoption of the amendments that we're discussing, particularly the warrant requirement, would anything in those hamper or restrict the government's ability to use 702 to target foreigners like you just described?
No.
Wouldn't at all, correct?
Not at all.
Not at all.
And what it would do, however, is ensure that you've got the protection of a warrant and your protection of your constitutional rights, particularly as a citizen, or as the ranking member points out, if you're here in the United States.
With
yes,
the exception of an emergency situation.
Which I was about to add to. Go ahead.
No, I mean, that you've said it well, but we even built that exception in.
And to take that further, so you've got bad actors here in the United States, okay, citizens or not. If we have the information about these individuals, right, there's nothing that would prohibit them from being able to go to present that. So somebody's cavorting with terrorists in some form. They're sharing information with Hamas. They're otherwise engaged with activity that would present either imminent harm or whatever the language is. I don't have it in front of me that would trigger an exception to the warrant requirement, or be able to actually get the warrant because they're actually engaged in criminal activity, because they're actually engaged with terrorists.
Good point. If you think that if you have good reason to believe, probable cause to believe that someone is engaged in terrorism, or that someone is planning to rob a bank,
Right.
you get a warrant. And it's no different. It's exactly the same thing. All we're doing is basically applying basic constitutional American law, and we're providing for the 3 emergencies that we've mentioned several times.
I know that we've talked about a couple of the other amendments, and I'll be mindful of time here. I know we need to move, but Mr. Jordan, could you expand just a little bit on, so we've talked a lot about the warrant requirement, but we also have Mr. Davidson's amendment, which I believe he'll probably have time to present later, but the extent to which why that's an important piece of this and was adopted in the context of our debate in the Judiciary Committee,
Yeah.
and why that's critically important, because there's a lot of arguments that say, oh, what's not germane? It's like, well, hold on a second. Committees of jurisdiction make determinations all the time. We bring bills before this committee all the time that have amendments that come in, we adopt them in the committee, and then that becomes the base product, regardless of whether or not that particular amendment might have had some touching to another committee's jurisdiction. We do that. And so my question to you is, why is that amendment valuable?
Well, to your point, it was in the bill that we passed out of the committee. So it was part of the underlying legislation that we passed, again, 35-2. And then I would also argue it's consistent with what we've been talking about. It's consistent with the warrant requirement because it says you cannot allow the federal government be able to go purchase information that would otherwise require a warrant. So this whole focus on the warrant entails and brings in that concept as well. And that's why we felt it was appropriate. That's why we put it in the underlying bill that came out of the committee. And that's why we'd have liked it to have been in the underlying bill here, but we'll take the Rules Committee, making it in order as an amendment.
And to quote one of our colleagues, and one that I believe our friend from Ohio, Mr. Davidson, might also quote in a bit, there's a distinction between, and we can have a debate, by the way, about whether insurance companies and other private entities should be able to buy all this data anyway. That's worthy of a debate. But in this context, it is a really critically important distinction that a private entity like an insurance company buying up this private data versus a law enforcement entity, be it the FBI or local law enforcement buying up this data, exceptions notwithstanding for publicly available stuff like license plates and other things. Because why? Because they can arrest you. Because they can bring the power of government against you. Would you agree?
One of our colleagues said, you know, we would all, one of our colleagues on the Judiciary Committee said we'd all be safer if we had a soldier in everyone's home, but we made a decision several years ago not to go that route, right? I mean, that's what we did. So it's called freedom, it's called liberty, and it's important. And we think we have struck exactly the right balance, consistent with the Constitution, consistent with our checks and balances and separate and equal branches of government, and how we've structured this. Again, I just hope we can win on the vote tomorrow on the floor.
I know there's another amendment. I'll go past that one, the abouts amendment, just in the interest of appeal. I know you guys all believe those three amendments are really important. There's another amendment that I'm offering, that I'd offered in committee, that would allow for certain members to be present in FISC proceedings. The amendment would allow the 8 plus judiciary chairman and ranking member. That's a modification, by the way, of where it was. We were going to say that any member of Congress could, obviously subject to all the classified requirements that we're all subject to, be able to go attend a FISC proceeding. That provision, which we included in the Judiciary Committee, Mark, was removed in the efforts to kind of reach some consensus. And I'm offering an amendment to put that back, as well as a provision that would require quarterly reporting requirements. I gave in to the ranking member and the chairman to make it quarterly instead of monthly. There was pushback that the FBI is incapable of doing that, incapable of putting together quarterly reporting requirements. So in my benevolence, I put in a 1-year build out for them to be able to comply with the onerous requirements of quarterly requirements to Congress in the amendment that I'm putting forward. Would the gentleman opine as to, you think, the merits of this? And I will lead into that.
Is your amendment now a year or a quarter?
Well, I give them a year before it applies so they can get their systems in order, because they can't possibly put a Post-it up and write down how many times, Americans have been targeted in this database. So, but in doing so, the reason I believe it's important, I just wonder if the gentlemen agree, is because notwithstanding getting warrants, notwithstanding getting all of these protections in place, there's still the possibility that people who want to abuse the system may, for example, rubber stamp those warrants. That there may still be a lot of questions about what happens in these FISC proceedings. So having the ranking member or the chairman of judiciary be able to attend a FISC proceeding, being able to check the interests of the executive branch, because, for example, right, political appointees from reviewing this stuff is worthless if we block that, right? It's like one of my colleagues said, I think it was Dr. Burgess, Lisa Page and Peter, they were career employees, right? And so we need to have the check of the Article 1 going over there and saying it, and then getting it, it's a mix of Article 1 and 3 over there, but go over there to the FISC and say, hey, what are you doing? And then the quarterly reports would give us more, I think it ought to be monthly or daily, but real-time understanding of, are they targeting Americans or not? And I just wondered how the gentlemen feel about it.
Well, I don't think it's crucial, but I do think it's useful, and I'll support it.
Yeah, I think it's a good idea, and I'd support it as well.
Well, with that, I believe that we're heading in the right direction. I'm still reserving judgment based on how this plays out. I hope that we'll proceed at least with the base plus these amendments and have the debate down there. But I will say the last point I'll make is One of my flags that are always up in this town is that we have the facade of regular order that is sometimes not regular order because something gets pre-cooked behind closed doors, and so you get an amendment that's already been decided. And I've seen evidence of this. I've seen things where you get placebo type amendments and things, and we've been trying to avoid that here. And I will compliment the Speaker's office and the Judiciary Committee Chairman and Ranking Member, as well as Intel, for so far moving down the line where we can get these votes on these amendments and hopefully have a real debate about this rather than using the obfuscation of intelligence and danger of the American people to scare them away from doing the right thing to make sure we're preserving civil liberties. I yield back. Well, to the Ranking Member.
I just want to say that, reiterate that I hope the committee will not make in order the 3 Intel Committee amendments that I've mentioned. We could spend a lot of time on the floor, and I don't know what the vote would be, but they're, from a civil liberties point of view, they're very harmful and they're totally unnecessary.
Well, let me associate myself with your remarks about my personal preferences and trying to work through the rules process here and figuring out the right approach. I yield back.
Mr. Jordan agrees with me?
Yeah, they would, as I said before, the Intel amendments are going to expand FISA.
Right.
The Judiciary Committee's amendments are going to control it and keep it in line with Americans' liberties.
Well, and to be clear, I'll just say here, I will oppose those amendments on the floor if they make it to the floor. It would be my preference they not even be made in order here in the structured rule environment, but we're trying to work through this process to figure out how we can get this stuff to the floor, get votes, and try to move the ball forward to preserve civil liberties, and we'll take that all under advisement. I yield back.